Guardianship is when a person loses their capacity to manage their personal affairs, either make health care decisions or financial decisions, to seek the best treatment for whatever they may be dealing with in their life. And guardianship is a vehicle that the clerks can use to appoint someone to make those decisions for them. Anyone can be a guardian. In my county, in my court, I want to make sure it's a qualified individual. That's what the general statutes say. Just a responsible person that can act prudently with the assets or the decisions that are being made for the ward or respondent. The difference between a power of attorney and a guardianship is not great. Both of them are what I like to call substitute decision-making power. A power of attorney means that you or I have decided we want somebody else to make decisions for us or spend money for us or help us with our assets or our medical decisions and things. So there's two kinds of powers of attorney, general and health care. In a guardianship, sometimes people can't make that decision because they're already past the capacity requirements to make a power of attorney. And so the court makes a determination that they no longer have that capacity, and they put them into guardianship by taking their rights away from them through an adjudication hearing and appointing an appropriate individual to serve. If you're ready to initiate a guardianship proceeding, you will need the appropriate forms. The forms can be in Johnston County, found from coming into my office. We have a packet that's available. There's a memo on the front of the packet that kind of walks you through each form in the packet. There's the petition, there's the certificate of service, there's notice of hearing, there's an order appointing a guardian ad litem. We actually include a capacity questionnaire so that the person filing the petition can go through and tell us the things that the respondent has the ability to do and not to do. Recently, in the last few months, the Administrative Office of the Courts has provided a guide and file electronic question and answer format that actually will prepare the forms for you. So you go to nccourts.org, you search for guardianship, and you'll be able to find the online services to prepare those documents. We get asked the question often, do I need an attorney? An attorney is not necessary. The courts are going to hear you whether you have an attorney or not. Sometimes it's less stressful for people to have an attorney. Attorneys know the appropriate protocols, they know the rules of evidence, they know how to present things. And so you don't have to have an attorney. Sometimes it makes it easier. The court date, when that comes after filing the petition, is a formal hearing. The petitioner will need to come with their evidence to appear before the clerk, who is the judge of probate and hears all the guardianship hearings. Any evidence needs to be ready to be presented as exhibits, and the witnesses will be sworn in, including the petitioner, to give sworn statements to the court about why they're here and why they're asking for guardianship. There's a guardian ad litem appointed, and the guardian ad litem will also give testimony as to his investigation about why the petitioner is asking for guardianship and what is in the best interest of the respondent in determining whether guardianship is necessary. After someone is adjudicated incompetent, there's always the ability to modify the guardianship. So if things aren't going well in a guardianship, then maybe the guardian and the respondent or ward aren't getting along and their decisions are different, and we need to appoint a different guardian, or situation changes and now the ward has money that they didn't have before and we need a guardian of the estate appointed. All that's required is filing a motion to modify. The guardian ad litem will be reappointed, and a new hearing will be set. At the new hearing, the movant, which is the person filing the motion, will tell the court what is changed and what they're asking to be changed. And the court will, after hearing from the guardian ad litem, determine if a change needs to be made in the guardianship. The modification is not exactly like the restoration. A restoration would mean that the ward has regained their capacity to make their own decisions. So you'd need to be able to show evidence that the situation or circumstances have changed. They are now able to manage their affairs. Mayhaps an infection that was causing them to be incapable of managing their affairs is gone, and now they're crystal clear and no longer have that disability that was making them unable to manage their affairs. So limited guardianship allows the respondent or ward, once they're adjudicated, is what the term in the statute is, ward, to retain some of their rights. So an adjudication of incompetency strictly means all of the rights of the respondent or ward are taken away. They don't have the right to sign contracts, they don't have the right to make medical decisions, they don't have the right to have a bank account and manage their funds. So sometimes you have a respondent that has incapacity in some areas but not in others. Or sometimes with people that have developmental type disabilities, they can do some things but not others. And I think it's very important that the things that people can do, they should be allowed to do. For some people, it's very important for them to retain the right to vote. Some people want to be able to decide who their friends are and who they get to visit, or whether they go to the church of their choosing. So while they may not be able to make their medical decisions because they don't have capacity to understand their medical condition, they still have a right to know who they want to be with and hang around with. Sometimes they have the right to work, but or the ability to work, they just don't know how to manage the money that they make. And so I think it's important to let people keep limited rights to learn how to manage money. And so sometimes the court can give the right to have a bank account and use a debit card that the guardian is watching and assisting with, but also giving the ward an opportunity to grow and regain the rights that they may have lost at some point. How you can be a good guardian or a better guardian is listen to the ward. Always be conscious of other people that are interested in the ward. Very seldom do you have a ward that lives in a vacuum. They have other family members, they have friends, they have people that want to visit with them. And so I think what makes the best guardians are people who can really substitute their good decision making for the ward who can no longer make decisions. If they enjoy playing the piano, make sure they have access to a piano. If they enjoy visiting with their friends, make sure they can visit with their friends. And visit and be a part of what's going on. Know what's going on. Being a guardian is not just providing a shelter and food and clothes. I think you have to be active and you have to know what's going on. And so is being a guardian like being a parent? Maybe in some ways, but I think the important thing is to not forget that they're still their own person. And even if you're the guardian and all of their rights have been taken away, you still need to give them the opportunity to be who they are so that they don't lose that in the process. Most of the time, people that have loved ones in these situations, they're already overwhelmed. So, they're trying to manage a health condition or a disability or something they really weren't expecting. A 18-year-old child in college has an accident and all of a sudden doctors won't talk to the parents. And you find yourself coming to get guardianship so you can take care of a non-responsive child. Well, I've seen several cases where in 6 months the child is fine again, but already they're overwhelmed and now they've got to come to court to get the right to take care of their child. and it's just very overwhelming. And so, we can go slow and we can make these things happen and we can help, and then we can put it all back together at the end once it gets straightened out. But I just find people are very overwhelmed by the idea of how do I get to take care of my family member when they're telling me I don't have the right to do that. But don't be afraid to come forward if someone you know needs help.